All right, I think we can probably start. So welcome all of you to the DVC Trust Estates and Succession series. And the purpose of this series, of course, is to try to create a forum for different stakeholders and professionals in this area of practice. And to those of you who are here for the first time, may I extend a very warm welcome to all of you. And to those of you who have been here before, then may I say thank you for joining us again, and thank you for your continued support. This event today is actually the second event in the series, and what we are talking about is really a very topical and practical issue concerning administration of estates, which is how administrators and trustees are actually appointed and replaced. Now, to many of us here, I'm sure that we will actually all be involved one way or another in the process, right? Whether we are actually seeking to appoint or remove the administrator or trustee, or whether as being the potential candidate being proposed as acting as the trustee or administrator, or even to act as the advisor or legal representative the advice of the trustee or administrator appointed. So this issue, we hope, is really one which has great practical significance for all of us, one way or the other. Now, in particular, you can see that even from the slide and the flyer that we've sent out, the angle through which we are actually looking at this issue, this very practical and commonly occurred issue today, is actually from that of the interaction between compulsion and choice. By that, we're actually seeking to explore really the process by which this appointment and replacement is done, and how much of it is really a matter which, say, court will mandate, or a matter which has to be compelled to be done, and how much deference will actually be given to the private parties, especially the beneficiaries of the estate and trust. And in particular, since we know that commonly the goal of the court is not to micromanage the trust or estate, what are the limitations which the court actually might have in terms of intervention in the first place? Now, we are very pleased and honored today to have Tiffany with us as our guest speaker. And as many of you here will know, Tiffany has extensive experience acting across the spectrum of different professional roles, from acting as administrator, trustee, to liquidator, receivers of company, as well as committees of estates of mentally incapacitated persons. So I'm sure that her insights and observations will be greatly beneficial for us to understand really the functions and roles of an administrator or trustee in the process. Now, as we've always emphasized, as we've said before, this talk is of course just part of the event. It's really meant to be a casual conversation starter, and we hope that really what happens next is the highlight, which is really drinks and food for all of us to mingle and to maybe share recent experiences over a more casual setting. Tiffany will start off by sharing some of the practical observations on the functions and roles of the administrator trustee. And then Teresa will follow up by discussing some principles concerning the appointment and replacement of trustee administrator. And then Terri will then share with us some things to look out for when we are actually choosing and proposing candidates for the appointment. All right. So with that, let's perhaps start with Tiffany. So Tiffany, may I again say a very warm welcome. Thank you for being our guest speaker.
All right, thank you, Kerby, and to Evo's Chamber, to Teresa and Terri as well for having me here. And welcome to you all. Kerby asked me to talk about the role of the trustees and administrator, right? I think in whatever role that we got appointed to by the court, one thing that is very close to our heart is preservation of the assets of the estate. This is the same across all spectrum of my service as administrator for deceased estate, Or,
Maybe it's better if I speak without the mic. Can everyone hear me?
Okay.
It's okay? Yes.
Yeah.
Yeah. Whether I act as administrator of deceased estate, committee of the mentally incapacitated person, or as liquidators or receivers of like companies and etc. I think, as I said, one thing that is like always in my mind and at heart is preservation of value and the interest of the stakeholders. Of course, for the purpose of deceased estate, which is the topic that we focus on today, is the interest of the beneficiaries. And we talk about whether we are appointed as the trustees or administrator. It really depends on, of course, before I got involved. It is always the case of the lawyers who got involved advise the lay client as to what is in the best interest and what is the legal right of the stakeholders and the beneficiaries are, and whether or not there's a will or the deceased person died intestate. So there are a lot of questions and issues to be determined by the lawyers before I come into the picture. Generally, I'll leave the legal issues and consideration to the lawyers, the barristers here with me on the panel today. But from a practical point of view, trustee, I act as a trustee. Of course, I look at the terms of the trustee very closely, and more often than not, a trustee or acting as a trustee would allow more discretion for the trustee to act. But again, it is the major or the only consideration I would say, in fact, is what is in the best interest of the beneficiaries. And if I got appointed as the administrator, for example, and also what power that is conferred on me by the court, right, under the order, and of course under the statute. And in this situation, when I got appointed as an administrator, in all the cases I got involved in, there are disputes and arguments among the family members or the beneficiaries, etc. And even you don't know there's a party who is going to come forward and say that I got an interest in this particular estate. You need to deal with me, and etc. and etc. So I think we'll move on to discuss about when you advise your clients or when the beneficiaries or stakeholders consider about the choice of the administrator. I think I also got some observation to share today, but I think it is for later, right?
Yes. Terri will probably, share more about the candidates. Oh, I think it's actually very interesting, Tiffany, when you mentioned about having to look at the terms of the trust and then to see what is really in the best interest of the estate, and as well as the starting part of the appointment. I think perhaps we can also explore that a bit. We know that one difference when it comes to acting as trustee versus acting as administrator is that for acting as administrator, you will first of all need to obtain the grant, right? Because otherwise banks and third parties generally don't really recognize, or they might not even wish to talk to you. They don't see the grant. And that of course is something which is not so much an issue when it comes to just acting as trustee of the trust. So have you encountered any issues in that? Because I think there must have been quite a number of cases where, because of delay in obtaining the grant, that would probably have led to some issues.
Yeah, just touch on a very real issue these days. Say we got appointed as administrator. Of course, we are trying our best. We write to all the banks, because in Hong Kong these days, I think I would say almost everyone, particularly we're dealing with some high net worth individuals, got bank accounts, right? Accounts at private banks and trust companies, and they got interest in in different listed companies, etc. We will be writing to all of them. Of course, we say that okay, now that we got appointed by the court as administrator, and we got an interest in them, please do not transfer the shares or deal with the assets without the express consent of the administrator. But this doesn't deal with our ability to actually deal with the asset, or unless and until that we got a grant from the court or like, a grant of like a letter of administration, that we don't have the power to actually receive the cash balances or the shares from the banks. And the problem that arises for me is that it means that the estate will not have liquidity to deal with the expenses and outlay that are incurred in the course of the administration. I'm not just referring to professional fees like my fees and the legal fee and etc. And a very simple thing as if there are some minor interest in the estate, or there's some dependents of the deceased, then we will need to deal with them, provide for them. And if the order for appointing us, or there's no order that will deal with the maintenance, then that will become a huge problem. Because of this involved legal proceeding, and it takes time, and there are different views among the the beneficiaries or family members. I call it beneficiary generally because the stakeholder are not necessarily named as beneficiaries under the will, but there are always people coming forward claiming that they have an interest in it, and say that there's a party which the deceased has been providing for and pay maintenance, and then come to us say I have not been basically I have no money, and because I've been depending on the deceased to provide for me, and I need to pay for my rent, or my mortgage payment. I got school fees to pay for my kid. I don't even have enough money to pay for my food next month. So what can you do? And this becomes quite challenging. And of course, we can say that okay, then we will make an application to the court, seek direction to the court as to whether or not we are able to get some form of direction. If there's some more liquid assets, say shares in the securities brokerage account, whether or not we can deal with it more quickly. But in reality, it's going to take quite a long time. I'm talking about months, not weeks. And I think these are the real challenges that we face these days. And I also take a lot, quite a few legal advisors from these guys here. And of course, I'm very conscious that I need to pay for my lawyers and advisors as well. And we simply don't have that resources to do so. So what do we need, right?
Yeah. I think what Tiffany you just mentioned is probably quite a sticking point in when we act for administrators and trustee, because it's a very practical matter, having funds in order to work. But the thing is, especially when you're talking about acting as administrator, as you very rightly pointed out, the grant is always quite important, but the grant and how quickly it's actually granted, even though there may be a court order, that is something which really is outside, beyond anyone's control, right? Oftentimes parties just can't control that, and there may be all sorts, I'm sure many of you here will be familiar, there'll be all sorts of requisitions that are raised, right? Requests about security, requests about showing this and that, and that could delay the process by quite a bit. So, in fact, one thing that we're actually exploring, of course, this is quite a organic, it's still a developing subject, subject to development every day. One thing that we have actually been discussing, exploring, is the possibility, perhaps for appointers who are actually proposing the appointment of or replacement of administrator and trustee, to perhaps also ask for certain directions, or at least some sort of liberty for the professional administrator to actually be able to have quick access to those funds, right? Because as we know, there is now, in terms of actual real life practice, there seems to be a gap, a lacuna, right, between the appointment and the actual, the acting by the appointee, in the sense that when the appointment comes, a lot of times the order, especially in the trust and estate context, it can be very bare-bones, right? It doesn't provide for a lot of things. It doesn't provide for powers. It doesn't provide for what the administrator or trustee can immediately do. It sort of expects that the appointee will then be able to take all the steps. So perhaps that might be something that can be catered for, in terms of during the proposal, even the appointment process, right? And then to try to solve this, because otherwise this is rather a tricky procedural issue.
And I would like to add that in one of the cases that are more complicated cases dealing with, which is very contentious. It involves, like, the estate involves some shares in some private companies of the family, and it's not been alleged that because the administrator's inability to take full control of the underlying companies, private companies, it has allowed like some of the directors to dissipate some of the assets out of the company, and that the directors of those particular companies actually, the siblings of the deceased, and then it very quickly that I was under some form of attack by the other beneficiaries that because you did not or you have not dealt with or take control over the subsidiaries quickly enough that allowed that particular person, that particular brother, to take advantage of the estate, which is like the lacuna that you talk about in transferring asset out of the estate and benefit himself. And then they would say that I told you he's a bad guy. You have to be careful with them. I mean, the counter argument I have is that you know him for 16 years. I don't. I just got appointed and have to be fair to everybody. I can't just assume that person to be malicious. So so it is getting very difficult. And unless the power of the administrator are dealt with in the order of appointment. Honestly, there's very little that we can do. Because we just can't assume, that particular person to be, malicious. Until, of course, then later on, we will need to incur costs and then, seek legal opinion as to, how we are able to unwind transactions and etc. That was undertaken by that, the directors of that particular company. But this is one of the very issues that we face these days.
It's a very practical one. I think on a slightly different matter, talking about the limitations. Sometimes I think when you're appointed as the grantee, administrator, or trustee, sometimes your powers may be limited, right? And I'm talking especially in cases, for example, where we're dealing with an estate, and what has happened is that you are given a preservation grant, right? What we call the ACE grant, right? Latin, or sometimes grants pending termination of litigation, right? So in those cases, essentially your powers will be limited to the expressly limited to the extent of preservation of either the whole or the part of the estate, right? So surely then that would have an impact in terms of, say, realization of assets, as well as dealing with requests for distributions, right? One would say. So, what was your take on that? I mean, in terms of experience, when you're encountered with a limited grant, limiting your powers only to preservation.
It is also very difficult. Yeah, of course, it's better than nothing. At least it is clear that we've got the power to preserve, right? Be able to at least get some the cash balances and the shares in the brokerage account, for example, to be transferred to my name, so that I make sure that they are in safe hands. And in a case that which we are dealing with right now is the reason why we were able to get the grant of ACB quickly is because there are already some evidence of dissipation by the wife of the deceased, and the children of the deceased basically was the one who made the application, right? But then again, we are not able to do a lot with such a limited grant. I think it's not until that we got full grant that we're able to at least we got the resources that is needed to act more proactively, like for example in clawing back whatever asset that was transferred out of the estate, unauthorized transfer, etc. And we know that it's going to take a while again, right, which is not helpful, from the beneficiary's perspective.
Yeah, I think so. I think what you're saying is actually very interesting. I think it's also quite insightful, right? Because certainly from lawyers' perspective, the books are quite clear, the principles are quite clear, right? You have the full grant on the one hand, and then you have all this list of different limited grants that are there's a supposed to cater for its every different situation. Because on paper, it certainly seems to be quite ideal. Because the limited grant, I think, as a matter of rationale and principle, it is meant to be a stopgap measure. It's meant to be there temporarily. A lot of times there could be real fights, substantive fights as to who should obtain the full grant. But I think what you've actually reminded us is that, as a matter of practice, if all you get is a limited grant, limited to preserving the property, there is actually very little that you could do, right? So there is a discrepancy between reality and ideal, right? So it's certainly a very good reminder when we deal with that. Now, speaking of which, I think Tiffany, you also touched upon one issue just now, which is dealing, whenever you are administrating a trust or estate, you have oftentimes, in fact, all the time have to deal with beneficiaries with different views, or sometimes they could be uncooperative. And I'm sure that must be quite a challenge because, again, as a matter of principle, you're supposed to be acting for their interests. You should be taking, of course, their views into account. But then reality, of course, is slightly different. So again, how do you try to deal with that?
I think it is like in my world or in the way that I deal with it, because I think everybody for these for most of my clients, the beneficiaries, the difficult bit is that of course they all got their own views, and more often than not they are not just here not acting quite sensibly. I would say that they also got each one of them got their own legal advisors, which is not always helpful, I have to say, right? They know about their legal right, but it doesn't help them in resolving their differences. I mean, this is why I said it's not always helpful, because it doesn't help them in resolving their differences. So the way that I think not just me, but I think other professional administrators would also try to bring them together, at least in the very first meeting, upon my appointments, right? And I introduce myself, what my role is, and etc. And you start to see some very interesting dynamic. I think it's important for them to sit together so that the same message is passed on to them, instead of they would say, okay, Tiffany, you're telling Kerby one thing, and then when they said but I heard different thing from Teresa, and then Terri say that you said this to Kerby, so you were not wrong. So I think it's quite important from a practical point of view, as a way or to resolve issues, or at least to present to them that I am a neutral party, a professional party that was appointed by the court. It's important that the consistent message or even the same message is passed on to them, and then I would invite them to each one of them to have private meeting with me, so that they can tell me one by one their side of the story, or what their wishes are, what they think, and of course they would be more than happy. I think most of them would be more than happy to speak to us, telling us what they think the deceased, their parents or whoever, what the deceased assets liabilities are, or who is acting badly before I come into the picture. So you actually collect a lot of information, and also take this opportunity to collect information from them, because as we also need to put together a statement of assets and liabilities, an account for presentation, right? For the purpose of the estate account, and also for the cost purpose for future applications. Yeah, for example, if we got a limited grant, when we apply for a full grant, we need to present to the court what the assets and the liabilities and obligations are of the deceased. So I often find this very helpful. But these days, because I think everyone are so well informed, and they pick up don't just to their own lawyers, but they also pick up a lot of information from public domain, and there are some there are a lot of information, but they will not interpret it in the right way. And I think it's quite interesting that I think in recent year, I got a couple of pretty difficult beneficiaries who keep on saying that if I don't accede to their request, they will say that I'll complain you, not to the court, because they know that if they complain to the court, they need to engage lawyers. They now say that I'll complain to Dongjiang Saimong, which is a very popular local TV forum that people like that complain to. I think this is the latest way that they exert pressure on the professional like administrator. And it's not that, definitely not that I do something wrong, but they just try to exert pressure on us that, if you don't do this and that, I will be like, making complaint. I will make sure that, everyone in Hong Kong know how bad you are. And, you can, of course I say this is like defamatory, but what do I do?
Yeah. Oh, that must be quite a difficult, challenge, requiring quite a bit of, your temperament and in terms of, keeping your attitude, calm manner despite all these sorts of challenges. But actually, I think speaking of, the beneficiaries and their legal representative, I think this is probably a good time to, invite Teresa to speak more in terms of, what are the principles involved when we're trying to appoint and remove administrators and trustees, right?
So, good evening, everybody. And first of all, let me thank Kerby for inviting me to speak on this topic, which I'm sure all of you know. The petitioners in this field do come across it very often and from time to time. And also we have the greatest pleasure to have Tiffany with us. And I enjoy so much the practical experiences just shared by you just now. And I would love to hear more, but perhaps without ado, I will spend the next 20 minutes highlighting a few statutory provisions relevant to this topic, as well as distilling from some cases the relevant principles in respect of their operation. First of all, I will start with Rule 21.1 of the non-contentious probate rules. This rule provides for the order of priority for grant in case of intestacy. If you can see from the screen, where a person dies wholly intestate, those having some beneficial interest in the estate shall be entitled to a grant of administration in the following order of priority. Firstly, the surviving spouse, followed by the children, including the issue of those children who have died during the lifetime of the deceased. The next category would be the father or mother of the deceased, and finally, the brothers and sisters of the deceased. Now, in case we do not have category 2 and 3, namely the children of the deceased and the father or mother of the deceased, in this respect, subsection 2 of Rule 21 provides that the right would be going to the grandparents as well as the uncle and aunt. So this rule is relevant when it comes to intestacy, and there is more than one party fighting for the grant of the administration. The other two sections in the probate and administration ordinance, which the petitioners in this field would usually need to turn to, include firstly section 36 of the PAO. I'll just call the ordinance PAO for easy reference. Now, for section 36, it sets out some, according to the court cases, some overlapping circumstances when the court can appoint the administrator. So if I may just set them out, where a person dies wholly intestate or as to his estate, or leaving a will affecting estate but without appointing any executor, and it appears to the court that it becomes necessary or convenient, the test words necessary or convenient, to appoint some person to be the administrator of the estate, or if any part of such estate, other than the person who, if this ordinance had not been passed, would by law have been entitled to the grant, then the court would appoint such person as the court thinks fit to be the administrator. So it goes to the appointment for section 36. Now, under 33 of the PAO, the same ordinance, this time it concerns the removal, subsection 3. The court, if it is satisfied that the due and proper administration of the estate, as well as the interests of the persons beneficially entitled thereto so require, the court may remove or suspend the executor or administrator, and then in their replacement appoint somebody else and invest the property into these other persons. So as you can now all see, sections 33 and 36 do come into the picture a lot. The court has in previous cases cautioned against excessive reliance on the cases and authorities. Now, after all, this topic is extremely fact sensitive. It all depends on the circumstances of the case that we are dealing with. So I'm not, it's certainly not my intention to just like go into the details of all the cases and authorities, and it's also impossible for me to do so within just 20 minutes of time. What I plan to do, as I have just said, is to let you know some general legal principles which we have to bear in mind when it comes to the operation of these two sections, namely section 33 and 36. Now, first of all, a very important case is the estate of Du Chi Chen. It's a decision of Mr. Justice Poon, as he then was. Now, there are a number of principles or the legal propositions derived from that case that I would like to highlight to all of you. Now, concerning the wordings, necessity or convenience in section 36, there are cases saying that these two words, as you would probably appreciate, they are of wide ambit, so it gives the court a very broad discretion as to how it should be exercised. But the cardinal, what is of cardinal importance is, as Tiffany has just told us, the administrator should always be acting in the best interest of the estate. And as to how the discretion will be exercised by the court, there is no confusion that it would depend on the circumstances of the case. And the court, in considering the application, would take into account not only the circumstances limited to the estate itself, but also extends to some other circumstances which the court thinks would be relevant to the application. And the burden goes to the applicant to satisfy the court that the circumstances of the case would require the order to be made. And in dealing with this sort of application, not only would the factual circumstances of the case would be considered by the court, but it has actually been expressly stated by the court in many different cases that the court would exercise a certain dose of common sense into the decision. And when it comes to like the passing over case, lately that an applicant is trying to ask the court to pass over a certain candidate, the court has made it very clear that some of the principles here would be of relevance. Now, first of all, in contentious probate, friction and hostility between the beneficiaries, it's virtually something that cannot be avoided. As Tiffany has told us in her practical experience, there are bound to be beneficiaries coming over to her saying that, A and B are not bona fide or are naughty or whatever. So it is well established now, according to the cases, that friction or hostility per se between the between an executor or a beneficiary alone, without more, is not something sufficient, or is not per se a ground alone would be constituting a good reason for removing a particular executor. It has been very well established that unless the hostility itself is grounded on the mode of administration, meaning that it would be like obstructing the administration of the estate. Otherwise, it would not be a factor that would be taken into account by the court. In other words, friction or hostility between an executor and a beneficiary alone is sometimes something that can simply be ignored by the court. What the court is concerned, it's certainly whether with the appointment of a particular candidate, whether it is going to be expeditious as well as economical to the administration of the estate. This is the primary consideration of the court. As you would all appreciate, the reason is clear, the logic is clear, because the court is concerned with the best interest of the estate. So unless and until the applicant, the party applying, will be able to show the court that the appointment is going to be like in the best interest of the estate, otherwise the application would just simply not be acceded to the court. So this is the first, in fact, a rule of thumb that we would all have to bear in mind in the application of this sort. In another case, the very well-known and the Stanley Ho line of cases. Now, in that, in one of the Stanley Ho related case, there are two cross applications, one by Ms. Patsy Ho and the other one by Ms. Angela Ho for the appointment of the independent professional administrators over the estate. And when it comes to the question of the independent professional administrators, this is where Tiffany would come into the picture. And in fact, that case is also one Tiffany has some involvement. Now, in that case, the two parties, the two Madam Ho's, they do not dispute that independent professional administrators should be appointed over the estate. The contention between the two camps was a very limited one, namely that whether an additional independent professional administrator should be appointed further to another professional administrators. Mr. Justice Wilson Chen, in that position, held in that case that, well, in fact, he reiterated the well-established principle that the starting point must be that the general practice, being a general practice, is that the choice of the majority would be preferred by the court. Now, of course, the respect for the majority, it's not something in the law book. It is more a matter of practice. But the court, Mr. Justice Wilson Chen, made it clear in that case that the idea that the court should reach a compromise whenever one minority set of beneficiaries take a different view is clearly not correct. This is especially so when the appointment of independent professionals already possesses the issue of there being different camps of interest. And this is also what Tiffany has aptly reminded us. Her role is an independent role. Her role is to secure the interest, the best interest of the estate, including the preservation of the assets and also the properties in question. Her role is not there to prefer the interest of any one particular camp. So in that case, therefore, Mr. Justice Wilson Chen finds it unacceptable for two independent professional administrators to be appointed. He took the view that one of these candidates would be doing his or her job good enough to secure the interests of the estate. And in fact, the judge also said that the view taken by Ms. Madam Angela Ho, her side, to be misconceived. Seems that her side was taking the view that with the appointment of an independent administrator nominated by her, her interest would be better secured. But it seems that the court made it very clear. Independent professional administrators are independent because they are not there to secure one camp or the other, but rather to secure the best interests of the estate. Also, in the decision, there is one more point in that decision which is worth highlighting. The court makes it clear that in some special situation, for example, where there are some minority, those underage, when their interests are involved, then according to the cases and the authorities, this is the situation where the court is required to appoint at least 2 administrators. And for your easy reference, it would be section 25 of the PAO, as well as some previous cases and authorities. But again, in that particular case, this special situation was not what in question in that case. So I will now go to another case. It's a decision of Madam Marlene Ng in Chao Chi Cheng and Chao Long Mei. Now, when Tiffany shares with us her practical experience, it actually now all falls into the place. Now, in that case, Madam Justice Ng highlights that an administrator is duty bound to carry a number of duties. Now, preservation of assets is certainly one, and also it's self-explanatory as to why it is an important duty or a duty of paramount importance. Now, apart from that, an administrator is actually duty bound also to do a number of things. Firstly, to truly administer and faithfully dispose of a deceased estate. And of course, in so doing, there are bound to be disputes when one beneficiary says that you are doing your job, and the other saying that complaining that you're not doing your job. And number 2, an administrator is bound to prepare a true and perfect inventory of the estate and effect. And when it comes to an estate of substantive size, especially nowadays when the assets are multi-jurisdictional, not just in Hong Kong or in the mainland, but involving bits and pieces in everywhere of the world. The preparation of the inventory could also be a challenge, and could also be involving the application of grounds not just from the Hong Kong court, but from other jurisdictions. And then it would be also, the administrator would also be required, obliged to render a just and true account of whatever that is required by the law. And given the duties of the administrators, therefore, in that case, one of the consideration of the court, of course, appoint submissions by one party that the other side, or the candidate nominated by the other side, is of bad character. Now, since in view of the duties that the administrators would have to undertake, therefore, whether a person has bad character would also be would be a relevant consideration for the court. And for obvious reason, a person with bad character would not be suitable to act as the administrator. But this is just a general principle, and we have to be very careful. And as observed by Madam Justice Ng in that case, not every element or not every complaint of bad character would be relevant. And what the court would have to assess is whether the complaint of bad character, if valid at all, would be a bad character that would go to affect or obstruct the due administration of the estate. And only in that case would such bad character complaint be relevant and be taken into account by the court in rejecting certain candidate. Now, as we've just previously looked at the cases and also from hearing from Tiffany, factual disputes, it seems to be inevitable in contentious probate of this sort. Parties are just expected to be doing all the finger pointing, saying that you've been acting mala fide or you've been dissipating assets and things like that. So, what is the approach of the court in handling this sort of complaint? Now, from the cases, it has been very clear. The court has made it clear. In fact, one of the decisions is by Deputy High Court Judge Mr. Justice Wong, saying that when the court is dealing with this sort of conflicts, factual disputes, the court is not expected at that stage with the existing evidence to make any factual determination, to come to any views as to which party is right or is wrong. In that decision, is Tian Sum and Yong Shui Tong, Mr. Justice Wong say that it would not be appropriate for the court to determine, in that case, the defendant's claim for interest in the property in question in those proceedings. The court held that, in that case, if the defendant were genuine about her claim for the property, what she should have done was to commence legal proceedings seeking recovery of the property. The court would in that case be equipped with pleadings and evidence, and then look into the issues and then come to a determination. But in the sort of application before the court would not make any factual findings. Now, but very interestingly, the court went on to observe that even though the court would not make any definitive finding in terms of fact, nevertheless, the defendant in that case, in commencing a claim of this sort, the court took the view that there was a conflict of interest. And the court also held that given that the conflict of interest alone would itself be a good ground for the court to order the defendant to step down as the administratress of the estate of the deceased. So you would now appreciate that when there is the existence of the conflict of interest, it's certainly a factor, a material factor that the court would take into account in consideration application of this sort. Now again, having said all this, nonetheless, the court would not just blindly take into account any complaint of conflict of interest. The court would still have to consider the complaint in the circumstances of the case, taking into account whether at least the conflict itself is something that is valid. Moving on to another case called Lai Shu Cheng. It's a case by Master Jack Wong. Now, speaking of conflict of interest, Master Jack Wong took into account the complaint raised by one party. And in fact, this is a case that Kerby was involved. And Kerby, in that case, submitted that where the conduct was under suspicion, then the candidate should not be preferred. And in the end, the court took the view that whether or not there was a conflict or whether or not a particular conduct was under suspicion, it's one of the relevant factors to be taken into account. But it's not the only factors in that case that would determine the result. Because the court again took the view that on the balance of other factors and also based on the state of evidence, in that case, he was not prepared to make any definitive finding. And the court observed that on the state of the affidavit evidence and without cross-examination, etc., it's only one of the factor that the court would consider amongst others. I've gone through a number of cases relevant to section 36 of PAO, and I'll spend the remaining 5 more minutes on the other 2 cases relevant to section 33 of PAO. Now, for section 33, it concerns the court's power to remove the personal representative of an estate. And in a case by Mr. Justice Johnson Lam, as he then was, in Chung Wing Kwai and Chung Wing Fai, it was made clear that again, the power given by the court under section 33 PAO is a very wide one. And the court makes it clear that it is not necessarily the case that a finding of misconduct on the part of the personal representative would be required. Ultimately, it would be an assessment by the court having regard to all the relevant circumstances of the case in considering whether or not removal is required. And again, the paramount consideration for the court would be not whether there is any misconduct, but whether there is, in the interest of the due and proper administration of the estate, and also the interest of the persons beneficially entitled in the estate, such a removal would be required. So you would all appreciate that these are all, again, very general principles, and we've been repeating times and again that the considerations for the court are best interest of the estate and the due and proper administration of the estate. So whether or not these conditions are met in a particular case, we would have to take into account the circumstances of that case and also pay attention to the facts. And this is also why at the beginning when I started, I've emphasized that the court has previously told the petitioners not to make excessive reliance on the cases and authorities, but instead to bear in mind the general principles. And this is certainly the case for each and every area, but in the context of the probate, especially when in the case of the contentious probate, it is more important. And lastly, the last case that I would like to go to is another decision of Master Jack Wong. It's a case called Yung Ka Ping. in that case, the court has spent some time on the consideration, the test, the necessity and the convenience test. And the court emphasized that in deciding whether to pass over a certain candidate who would otherwise be entitled to the grant under the ordinance, the court emphasizes again that the consideration would be not just the friction and the hostility between the parties involved, but also in that case, a very interesting aspect is that there is the appointment of an independent committee by the court in the mental health proceedings. So we would see that this is also whether or not a certain independent party is involved is certainly also one of the consideration having previously been considered by the court to be relevant in this sort of application. So, these are the few general principles that we would bear in mind in assessing cases involving the operation of whether or Section 33 or Section 36 on the appointment and the removal of the administrators. So,
yeah, thank you, Teresa, for the very comprehensive discussion regarding the principles, and I'm sure we'll all take home, I think, some of the key themes that we do see coursing through the different authorities about it being fact sensitive, about the timing and the intensity to which the court will scrutinize the facts, and to which friction and hostility actually taken in their proper perspective. Right? I think it's really something that has to be realistically viewed and has to be viewed through the lens of common sense as well. So lastly, I think perhaps we can also invite Terri to share with us the principles and in terms of practice of choosing, proposing the appropriate candidate.
Well, first of all, I'd like to thank Kerby for inviting me to join this experienced panel of speakers, Tiffany and Teresa. I'm going to be spending the remaining 10 minutes talking about how to choose the right candidate for both administrators and trustees. So the very first trustee or executor usually stems from the will or the trust instrument itself. But there will be situations where the personal representative or the trustee will need to change. I will briefly discuss some of these situations, which it might occur, and where there might be different rules on who would choose and appoint a new trustee. But when this happens, the role of the courts are actually relatively limited. It's largely left to the beneficiaries to choose, propose, and nominate a candidate of their choice. And it is only when they cannot agree that the court will be invited to make the determination. However, as seen from the cases, the courts also don't really scrutinize in depth the candidates, at least compared to other offices. And the court would also generally give preference to the candidate that the majority of the beneficiaries prefer. So just very, very briefly on the situations in which the personal representative would change. Someone nominated as the executor or the person with priority to be the administrator is free to decide and renounce their office. But they cannot do so if they have intermeddled in the estate. And for changes in trustees, for voluntary retirement, if a trustee wishes to step down, there are limited ways to do so. Under Section 40 of the Trustees Ordinance, this gives a way to do so without the appointment of a new trustee. And this can only be the case if there will either be a trust corporation or at least two people acting as trustees. And under Section 37 of the Trustees Ordinance, where the original trustee is deceased, remaining out of Hong Kong, desiring to be discharged, refusing or being unfit or being incapable or being a person under the age of 21 years, a replacement will be chosen by the appointer, which is the person named in the trustee or the will, to appoint future trustees, or if not, the current remaining trustees. This is the more interesting part, which is the statutory jurisdiction of the court to appoint new trustees. Situations in which this may be used are to appoint new trustees or to replace current trustees. And it is applied when it is expedient to appoint a new trustee, and it is found inexpedient, difficult, or impractical to do so without the assistance of the court. However, this statutory provision only applies to trustees. It doesn't apply to personal representatives, which will use the provisions that Teresa has just discussed. The court has also held that it has an inherent jurisdiction to do so, which is part of its power to administer trust. This case is a recent example where the court considered a beneficiary's application to remove and replace an existing trustee. And the court helpfully summarized some legal principles, and they're actually very similar to the principles that Teresa had discussed. To show that a new appointment is expedient, actual misconduct on the part of the trustee does not need to be shown, but the court must be satisfied that its continuance in office would be prejudicial to the due performance of the trust or impede the effectual execution of the trusts, and so adversely affect the interests of the beneficiaries. The welfare of the beneficiaries is still one of the first considerations by the court. In deciding whether to exercise its discretion to appoint new trustees, the court will take into account the wishes of the person by whom the trust was created, so the settlor, the interests which may be conflicting of all the beneficiaries, and importantly, the efficient administration of the trust, and whether the appointment would impede or promote the execution of the trust. The approach of the court will depend on the gravity and the nature of the breaches and the particular circumstances of the trust and the trustees, including the level of culpability. But generally, the act or omission must be one that endangers the trust property to show want of honesty or want of proper capacity or want of reasonable fidelity. These were some cases that were quoted by Deputy High Court Justice Rachel Lamb in that case. Letterstead and Bowers. So again, this highlights that it is the beneficiary's interests that are important. And same for this case, that was quoted in the judgment. Of course, everyone will know that there are some minimum eligibility requirements, but something interesting from this case, trustee of the property of Lau Ip Po, is that a bankrupt can actually be appointed as a personal representative for the purposes of Order 15, but it is generally undesirable. And of course, there's a general rule that bankrupts will be removed on the ground that there are risks to the trust property. And on the appointment of a trust corporation can be appointed whether jointly or alone, and a firm operating as a partnership may also be appointed by appropriate wording. But since a partnership doesn't have legal personality, this would normally mean the partners at the time being. So it would be useful for the trust instrument or the will to specify whether it be the partners at the time of the death or the partners at the time that the will is being executed. And if successive partners are to be included, then this should also be specified. So turning to the specific choice of candidates. I've seen some old precedents that have sometimes said that beneficiaries may not be appointed as trustees, but this must be wrong. Beneficiaries can be personal representatives or trustees, and it may even be desirable for them to act. They will have the most familiarity with the settlor or the testator, with the deceased situation, and especially when their duty is to locate the deceased's assets, they would, and understand what debts and what claims that they may have. And of course, there would be a saving on costs because beneficiaries will not normally be remunerated. The key concern is that there would be conflicts of interests if a beneficiary was to act as the executor or the administrator. But this risk is manageable and shouldn't be an impediment to appointing a beneficiary as an executor. This can be addressed by safeguards inserted into the will or the trust instrument. First of all, the testator wouldn't appoint the beneficiary unless he was confident that they would act properly. And usually the beneficiary wouldn't be appointed as the sole trustee or executor. There could also be an independent trustee, such as a professional trustee, so that the beneficiary isn't acting alone. Or there could be a balance between different parts of the families. For example, if a settlor has 2 children, then both parts of that family can be represented as executors or administrators of the trust, or the will, administrators of the will. The terms of the will could also have provisions on self-dealing. For example, it could prohibit them to sell property to themselves in their personal capacities. It might prohibit a trustee from exercising power in their own favor without the concurrence of another trustee. It could also introduce provisions on selling on commercial terms, for example, so limiting the price that property may be disposed at. Also, generally, a trustee is not able to exercise a fiduciary power for himself unless the trust instrument expressly authorizes them to do so. So it is also prudent to include that in express terms. And that will usually be a question of construction, so express terms would be preferred. And turning to professional trustees, administrators, the benefit of corporate trustees is that it provides continuity in the trusteeship. Corporate trustees will not die, they will not retire. But on the other hand, the personnel in charge of the corporate trustee could change. And this would often be without the knowledge or the consent of the beneficiaries and the settlor. Trust companies can also be sold, so the continuity aspect, this is something to be borne in mind when considering the continuity aspect. Fees are often a consideration in appointing professional trustees. It will of course be relevant to the economical administration of the estate, as Teresa had pointed out. And of course, the executor and the administrator should also be willing to accept the statutory cap, which is provided by section 60, subsection 2B of the PAO.
I think just on that, because I was speaking to Tiffany, I think Tiffany might have something to add to that as well, right? The fees proposal. Yeah, I mean that is probably the most practical question whenever it comes to being appointed, proposed as acting as candidate. What the fees are and how you actually present it.
Yeah, you just get me started. Yeah, again, it is another impediment, I think, to the general administration of deceased estates. I mean, we're talking about like some high value estate here, not like those small ones with very limited value of assets. You just think about it. We are all like professional administrators, and And as I said earlier, the reason why, like, a professional administrator or trustees are required to be appointed is because, in all the cases that I am involved in, there are lots of like disputes and disagreements among the parties. If the the beneficiary themselves or among the family member, they can agree that maybe okay, I'll appoint. We all agree to have the eldest sister, the eldest brother to be the administrator or the executor. And there's no need for the involvement of professional. And as Terri pointed out, for those kind of situations, they are not remunerated. But when the stakeholders, the beneficiaries don't trust each other, this is why they need to bring in professionals. And I think the limitation of the statutory of the statute in terms of the fees of administrator make our life really difficult. You look at it, I mean, if you're talking about like a high value asset, I just don't think it is fair for the administrator to limit ourselves to this cap. And okay, in practice, of course, we can't there's nothing I can change right now. But so I think not just me. I think the other professional, the way that the other professional administrator do is we propose that okay, say like Tiffany Wong as the administrator, my fees and my time is limited in accordance with Section 60, Section 2. But I also engage and use resources from my firm and say the law firms, and they are not bound by such a cap. So this is the only way that I see that make it work in practice. As otherwise, I'm afraid it will be even next time when Kerby, Teresa, or Terri, or the lawyers approach me to submit proposal. I just don't think that it is feasible for the estate to expect that a professional administrator will be acting in the way that it should be because of this kind of cap. Yeah, and it's not just as simple that we just preserve collect in asset and preserve them. We also got in all our cases some litigations to be dealt with, and just I don't know whether there's any proposed reform in regard to this particular section, but I think over the long run I think this is needed.
Yeah, no, I think, I definitely agree. There's probably an area, section which is overdue for reform of anything. The cap was, imposed years ago, decades. And then, it's something that has to be revised, whenever you are looking in terms of the commercial realities. But nonetheless, because of the, and I think this was premise as well of UK legislation, more or less because of that. And now there is this, it's being enshrined in statute. I think that just makes the updating process much more, trickier than it otherwise would.
Yes, and that must be difficult, but the court will also, I mean, what the courts have said is that the fees of the administrator should never significantly deplete the assets. So, and I understand in a situation where it is a very big estate that you're concerned with, surely there should be some reform in that sense. And then turning to the choice between accountants and solicitors as the professional trustees. Whether an accountant or a solicitor should be appointed really involves a balancing exercise on whether the legal aspect is more complex or the accounting aspect is more complex. But in reality, even if an accountant is appointed, they will often seek legal advice from solicitors, and when a solicitor is appointed, they will also have the benefit of advice from an accountant. Of course, an accountant and a solicitor have very different skill sets. For solicitors, they are geared towards dealing with matters with more of a contentious element, where there are family arrangements or family deeds. Solicitors would be more experienced in interpreting them, or if there are potential litigation that the estate is facing, then a solicitor would be able to represent the estate directly. Or even if it's a very contentious matter between the beneficiaries, a solicitor also has experience acting as a mediator and would perhaps be able to bring the two sides together, or find it suitable to seek directions from the court. Also, solicitors have more experience in conveyance. So if there are a lot of landed properties to be sold, then solicitors would have more experience in dealing with that. On the other hand, of course, accountants are more number savvy and would be able to navigate more complex estates and complex financial statements. This is particularly useful if the estate consists of a lot of businesses, and it's important to have an inventory of the size of the estate, and using forensic accounting to trace and identify missing assets. However, an accountant cannot act as a trustee if the firm also audits any of the companies that are in the trust estate. And perhaps Tiffany can tell us a little bit more about when the expertise.
Yeah, actually, I agree with what you said, but I think just one thing that reading the notes that you have on the screen and about the cases, I think the one highlight that I have is that when you consider, when you because it's all case specific, but I think the cases in which that it is more beneficial, probably more beneficial for accountants to be appointed is that are those with allegations of fraud, and there are a lot of transactions, etc. And I think when I talk about accountants, I'm not talking about just an accountant with auditing or tax skill set, but I think those kind of situations it actually requires accountants with forensic and asset tracing ability. Yeah, because I think the precedents that you mentioned, I think there's some wording about bookkeeping. Certainly, asset tracing and forensic accounting is way more complex than bookkeeping, debit and credit. So I think in those situations, I think it would be more beneficial for accountants to be involved. And as Terri just mentioned, if there's a need of because we work very closely with solicitors and in litigation with the business where we take to counsels. So I think it just really depends on the situation. And of course, if there's no allegation of dissipation, etc. I think it is I think you're right. Probably solicitors are more equipped for the situation.
So just to wrap up, I'd like to go through some examples of to show that it really depends on the circumstances of the case, whether an accountant or a solicitor is more appropriate. This was a recent decision, Ren-Mickey, where the court had to decide between solicitors and CPAs for the administration of the estate. And the court decided that a solicitor would be more appropriate.
Don't look at me.
This is a case for our very own Alfredo. So the relevant factors were that the estate in question was actually relatively simple and straightforward. It didn't require complex accounting. The nature of the case was very contentious, and there was an ongoing litigation between the parties. So one sentence I'd like to highlight is that an administrator who is a solicitor may have more experience of attending in person at a hearing before the court. So, and then this case, Lai Suit Ching, Master Jack Wong. Again, the solicitor was chosen over the accountant. On the particular facts of this case, the distribution was relatively simple. It was to be divided in 7 equal shares. There was a family arrangement in place between the parties. There were some legal issues involved, such as identifying the estates of the deceased. There was also an ongoing litigation, and therefore the issues would require legal expertise. But again, even if a solicitor is appointed as the administrator, you would often have the advice and seek the advice of accountants. On the other hand, in this case, even though the court wasn't confronted with a choice between solicitors and accountants, and it found that appointing an accountant was the best decision for this trust, for this estate, because the trust consisted of a business across a number of entities, so that the accountant was suited to render complete accounts and accurate valuations of the business. And finally, in this case, Choi Po Chung, the court was asked to pick between various different corporate trustees. And they chose HS trustee. And the reason for this was because it was the only candidate specializing in trust matters. So this case really serves to highlight that experience in trust matters and estate administration is quite different from restructuring and insolvency, and it is one of the factors that the court will consider, experience in administering trusts and estates specifically. So really, just to wrap up, generally it is common that for small trust to have 2 or 3 family trustees who carry out the administration of the trusts themselves and instruct professional advisors when they need to. For a medium-sized trust, usually a mix between family members and individual professional trustees. And for large trusts, corporate trustees alongside 1 or 2 family trustees. And I think now we have some time for some questions.
Thank you, Terri, thank you, Teresa, Tiffany as well. So I think what we'll do now is perhaps, just like last time, we'll skip the question and then go directly to drinks, so that we can of course continue to speak and exchange, and if you have any questions, feel free to ask our speakers. But let's do it over drinks, because I think we're slightly running over schedule. Thank you once again for coming. This is of course not the end of the event, so you can join us for drinks. Just a quick preview, as we've done before. This is a series, and the next one that we have scheduled will be sometime in March and April. So again, for those of you who are interested and available, we would definitely welcome you and encourage you to come and join us again. Otherwise, thank you all, and we'll speak further during this.